The following program, offered by Fox 19, includes lawyers licensed in Kentucky. For those lawyers to maintain compliance with the Kentucky Bar Association requirements, the phrase, "This is an advertisement," must appear on the screen. Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Welcome to More Law. Today our topic is employment law. We're discussing employment law from discrimination to drug testing, overtime to employee benefits. What are your rights at work? When can you be fired? If you're having problems with your boss or coworkers, or if you're a boss having trouble with your employees, give us a call at 513-421-4691. The phone lines are open right now, but let's take a look first at what we have coming up over the next couple of weeks. On August 27th, Careers in the Law. September 3rd, DUI. September 10th, Business and Estate Planning. Here with me today every Monday morning, Don Moore. How are you this morning?
I'm doing great. How about you, Deb?
Good, good. Busy weekend.
You had a killer weekend, didn't you?
We did. I work at Big Brothers Big Sisters. We had a 5K this weekend. Mike's Car Wash is around town. Did a big fundraiser for Big Brothers Big Sisters. Thanks to Frank Marzullo and Tracy Johnson and my husband Eddie Fingers for joining us at some of those sites. We had a great day.
That was a great weekend, wasn't it?
It really was. It really was. And my youngest son got to spray those hoses at Mike's, and they had pretty big kick to him for that 10-year-old boy.
All right. Well, I'm glad he had fun, and it sounded like you were really busy. Hey, you know, today we've got a great show. Peter Burrell is with us today. Peter, thanks a lot for coming.
Thanks for having me.
Peter he does employment issues. He represents both sides, been doing it for over 25 years. He also teaches in the MBA program at University of Cincinnati, and this is something, he's with Strauss and Troy. He made the super lawyers list because he's a super lawyer.
Sounds like we have just the right person on to join us today.
Indeed.
All right, well, thanks for being here.
Thanks for having me.
And I know we have some calls coming in, so why don't we get started with that? We have first off Sean in southeastern Indiana. Sean, you were fired from your job, right?
Yeah, I have been terminated.
Okay, well, tell us about your call then.
The question is, should I get an attorney? And if so, which attorney would be tough enough to take on a giant corporation? Now, the situation that happened was I was employed at a large rental car company. We'll leave them unnamed. I became the union steward after about a year. I negotiated a new contract, which totally made the general manager there very upset with me. A month later, I was laid off due to a quote-unquote lack of work. I was called back. I received unemployment while I was laid off. Was called back a month later, demoted, had a lesser paying position, didn't have the same job as I had before, and eventually, to make a long story short, was brought up 3 times in a row by them and terminated. Now, since I was brought back, I have filed labor board charges against the union and the company to later drop them against the union so I could go forward with what I need to do. But right now, as of yet, they have fought me on unemployment, and it has been 6 months.
Okay, let's go to Peter. Go ahead. I would think that these things, are so complicated. And Don, you were going to...
Just as a prelude, let me just mention one thing, Sean, and that's very simple. Lawyers love to take on big corporations. Big corporations make great targets if they deserve it. And that's something Peter's got lots of experience with. How can we help Sean?
Well, 2 things I wanted to comment on. One, it sounds like you're a union employee, and that's a good thing. Generally, if you are a non-union employer, you are an employee at will, which means you have limited rights. So in this situation, you're doing the right things. You've filed some labor charges, but it sounds to me like you do need a lawyer, and I would find somebody that has some experience with union kinds of issues, and they're used to dealing with big corporations because those are the ones that have unions.
Isn't that pretty intimidating, though, if you're the employee and you just feel like you're one person?
Yeah, absolutely. And you need help when you're an employee. Absolutely, no question.
Although, frankly, when you're in Sean's position, you've got nothing to lose. They already took your job away.
Well, that's true.
So go get them.
Indeed. Well, and he has a union. They're supposed to help.
Okay.
So.
All right. Next up, we have Deborah in Cincinnati. Go ahead, Deborah.
Yes, I was working for a company and I witnessed sexual harassment. We were taken into the office. I was asked to write a statement of what I saw, and that a representative from their company, because they didn't know how to handle the situation, on site would contact me within the next 2 working days of the following week. The day that I wrote the statement and took it into work, they let me go and the man who I witnessed doing the sexual harassment. That's my question.
Well, it sounds to me like you have a good retaliation claim. So what you need to do is probably find a good lawyer that would help you in that situation. I'm surprised that the company looked to fire somebody that was participating in a sexual harassment investigation. It sounds to me like you may have a good retaliation claim.
Okay.
So tell me, when you say a retaliation case, what do you mean by that? From an employment law speak, what does that mean?
What a retaliation claim is, and basically every anti-discrimination statute that protects employees has an anti-retaliation provision. And what that means is that if you participate in the investigation or you're a witness and you have helped the process along, if the employer takes an adverse employment action against you, that is actionable as a retaliation claim.
Okay, thank you.
Yeah.
Okay, I think we can get one more call in before the break. Holly in Cincinnati. Holly?
I work at a hospital, and the employers, when you clock in, they say that you have to clock out, and they make you stop, like clock back out if they don't want to pay you for that time. And like, I'm sorry, I'm nervous.
So could I help, Holly? It basically, is your question that, are they allowed to clock you out while you're still working? Is that your question?
Mm-hmm.
Okay. Peter, what do you got for Holly?
Well, that's an interesting situation. The wage and hour is a big, hot area in employment law right now. And your employer, if you're supposed to clock in when you get there, you clock in. When you're done with your shift, you're supposed to clock out. It sounds like your employer is making you clock out before you're done with your shift. You might want to put a call into the Department of Labor.
Okay. All right. We will be back talking about employment law. Please give us a call, 513-421-4691. We'll be right back.
Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
Welcome back. We take you now to your More Law Connection, where Dan Moore is answering viewer emails. Good morning, Dan.
Thanks, Deb. Our first question is from Summer today. She writes, is it legal for a babysitter to give a child medicine without permission? I've got 2 answers for that. First is, if it's a medical emergency, the answer is yes. The babysitter always has a duty to protect that child. The second answer is, if it's not a medical emergency, then a babysitter must act reasonably. In this situation, the best way to act is not to give medicine unless you've got the parent's permission. End of story. Deb, back to you.
Thanks a lot, Dan. We'll see you again in a minute. Let's get back to the phones now. We have Denise in Cincinnati. Denise?
Yes.
Go ahead with your question.
Okay, yeah, I have a question. I was terminated from my employment because of, they said I was a lack of, I lost my job. They said I was not doing my work accordingly. Okay. I never received any verbal warning, any written warning, or anything. And I received unemployment, and now they're appealing it.
Is there anything she can do about that, Peter?
Yes.
Well, first of all, you're doing the right thing, which is to appeal that. What your employer is claiming is that you were terminated for just cause. That's a fairly difficult thing for an employer to prove in the unemployment arena. Unemployment is designed to be a safety net. And if you were let go for lack of work, it sounds like they let you go for something that they're claiming that you did wrong, they have to prove that.
Okay, great. And I think, go ahead, Don, you were going to say?
Well, yeah, I was going to ask along the same lines of that last caller. She said they didn't give her any warning and she wasn't doing her job. I've heard of employers sometimes snooping on email, either looking at your email or putting a tattletale program on your computer to see where you spend your time when you're on your computer. Right. Are they allowed to do that?
The answer is it depends. Most employers that I advise, I tell them to put in their employment handbook that they have the right to do that, and that their employees have no expectation of privacy in the computer equipment or the PDAs or the smartphones that they are given as part of their employment. So that's the smart thing to do if you're the employer, and that does allow them to snoop on the emails and whatever else they've provided as part of the employment.
Do you find that they do that a lot?
A lot, maybe not, but a fair amount, yes.
Is it more of a cause, like I think somebody's doing something and you go, or is it more, do you have to do it in a, we're looking at everybody's records?
They can do it in either case, but I see it more frequently when the employer suspects that the employee is not doing their job or is spending too much time on non-job related things at work on the computer.
If they don't warn you and they don't get you to sign off on it, are they liable?
If they can terminate you at any time for any reason that's not illegal. That's the definition of employment at will.
Okay.
And good employers have that set forth in the employment application, in the handbook. It's posted everywhere. So can they get rid of you without warning? Answer yes.
Okay. Thank you.
Let's head back to the phones now. We have Lisa in Cincinnati. Lisa, I understand you have a question about some mandatory meetings that you had to attend.
Right. I worked at a place, and they would have mandatory meetings, but they wouldn't pay the employees for being there. They said they would put the equivalent amount of money into an account for you so you could purchase stuff from their business. And that's how they paid you for that. And I wonder if that's legal.
I wonder too.
Well, that's an interesting question. The last part of it was kind of a little bit of a curveball. I've never heard of that happening. Let's go back to the mandatory meeting. If they are requiring you to be at a meeting, they are required under Fair Labor Standards Act to pay you for the attendance of that meeting. I've never heard the last part of that, and I don't know if they can get away with that one, but I would definitely, that's another call to the Department of Labor or to a good lawyer that specializes in this area.
Okay.
Yep.
All right, let us head back now to Dan Moore with another email question. Dan?
Okay, our next question is, are you always at fault if you hit a car in front of you? Well, the answer is probably 90+% of the time, yes, you are. If you are driving a car, Ohio, Kentucky, and most states have a law that says that you have a responsibility to maintain enough distance between you and that car in front of you in order to safely stop your car. Now, there's some exceptions to that rule, which I wouldn't count on if I were you. One exception is if that car in front of you cuts you off and makes it so that you can't stop your car. If that happens, then you might have a valid defense, but don't count on it. Most crashes where this scenario comes up, a police officer is going to assign fault according to the rule of you need to make sure you have enough distance in front of you. So, if you have a question, go to fox19.com. Go to the More Law button on the top of the page, fill out the Send Us Your Questions form, and submit it. And we will do our best to answer your questions. Deb, back to you.
Thanks a lot, Dan. Of course, we'll see you next week. And right now, we are taking a break, and we'll come back with more of your questions about employee-employer relationships.